So, if you're joining us today, chances are you've reached a point where you're thinking not just about your own retirement, but also about how to help your family while you're still here and leave a meaningful legacy after you're gone. And you are in the right place. Our host today is somebody who spent more than 35 years helping families and especially grandparents protect and grow their wealth with smart, tax savvy planning. James Lange is a CPA, an estate attorney, and a nationally recognized expert on Roth IRA conversions, retirement plan distributions, and holistic tax and estate planning strategies. Jim's retirement planning strategies have been featured in the Wall Street Journal 37 times. He's the author of 10 best-selling financial books, including Retire Secure, and he's a paid contributor to Forbes.com, where he's published more than 20 articles on the strategies that he'll be covering in this session today. His work is endorsed by some of the country's top experts, including Charles Schwab, Burton Malkiel, Ed Slott, Larry Kotlikoff, and many others. But what sets Jim apart truly is his ability to take complex tax law and turn it into clear, actionable strategies. He published the first peer-reviewed article on Roth IRAs in 1998, predicted the end of the stretch IRA years before Congress enacted the Secure Act, and recently implemented a strategy for his own family that, given reasonable assumptions, will save over 1.1 million in taxes over his daughter's lifetime. And he's actually going to do a case study on that strategy in this session. And that strategy was also featured in the Wall Street Journal this past December, and he did a detailed article on it last month for Forbes.com. Through his interrelated firms, our CPA firm, which is currently preparing more than 750 tax returns, and a registered investment advisory firm that helps manage and plan for nearly 1 billion in assets under management, Jim and our team have helped hundreds of families build personalized financial master plans. Today's session is packed with strategies that grandparents can use to spend confidently, gift more strategically, and leave a tax savvy legacy. And the best part is that you'll be able to apply and benefit from these strategies whether you decide to work with us or not. So please join me in welcoming Jim Lange.
Thank you, Erica. So we have a lot of stuff today, and we're going to emphasize what for, I believe, most married grandparents is the best estate plan, and even for people who aren't married grandparents, the concepts which will apply to most everybody. We're going to talk about what happens if you don't do anything, and the cost of not doing anything and the cost of not optimizing your estate plan. We're going to be talking about some of the details of this solution, and it goes by two names. One, in the snooty peer review journals, you'll see it called the Cascading Beneficiary Plan. In my literature, it's called Lange's Cascading Beneficiary Plan, and I've been putting these plans to work since 1995. A little more on the history of that later. And we'll talk about disclaimers and what disclaimers are and how they build flexibility into your estate plan. And we are going to do a true case study, and it's one of my favorite clients, which is me, because I implemented this strategy for our family, and I'm so excited about it. I want to tell the world about it. It will apply, and there will be benefits for most every grandparent. If you have a grandchild that has a special need or would qualify as an eligible designated beneficiary, it can be truly life-changing as it was for our family. And we call it the win-win, which is using disclaimers to provide for a grandchild who doesn't have a disability, but some of the advantages and why it could work. And then again, the bonus session for grandparents who do have a child with a disability. And I'm going to get to the solution, but I don't think that it would be premature if I didn't do let's say, the concepts. And this, like I mentioned, I had started doing these plans in 1995. And many of these folks have since died, and we have seen the benefits of this plan, which I think is truly amazing. And I'm so excited. And I've done some variation of this talk, probably for 30 years to estate attorneys, financial advisors, end users. And I still think it is the best estate plan for most grandparents. And then, of course, the solution itself. Let's get back to some of the issues that we have, which is the Secure Act. It's nothing like the Secure Act. It should be the Insecure Act. And basically, it says, subject to exception, that after you die, your IRA, which let's say for discussion's sake is not a Roth, although it's similar rules to Roth, but it must be distributed within 10 years of your death. And even if it is a Roth, it still has to be distributed within 10 years of your death. The difference is with a Roth, it all comes out income tax free. With a traditional IRA, it is all taxable. So this is pretty miserable, particularly if you have a million or $1 million plus IRA, and that whole thing is going to come out within 10 years, adding, let's just say, an average of a little bit, well, it's going to be more than $100,000 per year because of the income on that. And if your kids are doing well, that's going to be taxed at a high bracket, which means basically your family is going to be paying enormous taxes if you don't do some of the proactive things that we're talking about, one of which was Roth IRA conversions. And there are exceptions. The most important exception, by the way, to the 10-year rule is the surviving spouse. In other words, you can leave your IRA or your Roth IRA to your spouse, and your spouse doesn't have to take it out within 10 years. They would take it out based on the joint life expectancy of them and somebody who is deemed 10 years younger than them, unless you have a spouse who's more than 10 years younger than you. Well, that actually refers to your minimum required distribution. But anyway, the most important exception is the surviving spouse. The other important exception for, let's say, the roughly 15% of you who have a grandchild or a child who is an eligible designated beneficiary, meaning they do have some type of disability, meaning that they could stretch that inherited IRA or Roth IRA over their lifetime, which is very important. But let's assume for discussion's sake that yes, an eligible designated beneficiary could stretch that inherited IRA over their lifetime. But if you have inherited IRA going to somebody who doesn't meet the exception, maybe they're just in a lower tax bracket than your kids. So particularly if they're young and they haven't really established their career, or even if they have and they're not making as much money as your kids, there's a huge tax savings between having money going to grandkids and to kids. And we're going to show you how you don't have to make that decision now. You can let your kids make that decision later, just like you can let your spouse make the decision of how much money they want to keep and how much money goes to the next two generations, and they can make that decision later. And again, even without a grandchild with a disability, there are some great tax savings along with this cascading beneficiary plan. So this chart shows the difference between the old law, which is in the green line, of what happens if you die with $1 million. And then in the serrated line, what happens if you die after the Secure Act, which is meaning in anybody who dies after the year January or after January 1, 2020, subject to the exception, they are in the, let's call it the serrated line, and dying before, or if they meet one of the exceptions, they are in the green line, and that's a $2 million difference. So this new law is absolutely miserable, and it's called the Secure Act. But that's the law. That's the law of the land right now. By the way, one of the benefits of being an eligible designated beneficiary is now you fit in the green line instead of in the serrated line, given identical exceptions, except the ability to stretch it for many more than 10 years. Obviously, Congress is literally picking the pocket of IRA beneficiaries, and notwithstanding that, they call it the Secure Act. So again, I've been doing these plans. I sold my law firm. So, and so by the way, I'm not here pitching, oh, come to Jim Lange for legal services. We don't even have a law firm anymore. Um, but for close to 40 years, I did have one. And I started doing this type of planning in the mid 90s. And since then, we've had a lot of people die with these plans in place. And what has happened is we have protected or overprotected the surviving spouse. We have saved families hundreds of thousands, sometimes even over $1 million in taxes. I've taught this to attorneys. I've taught this to CPAs, to financial advisors. I used to get back a long time ago when hardly anybody was getting 10,000 bucks. I was getting $10,000 a day to teach this to other folks, and tens of thousands if you include consumers, books, digital media, etc. And one of the biggest problems with estate planning is uncertainty, right? There's so much we don't know. What will the laws be like when you die? Who will die first? How much money will be left? What are the needs of the survivors? What will the tax rates be? Where will you die? Where will your kids live or your grandkids live? If we knew all this, we could do a much better estate plan, but we don't. So what should you do? Well, we love doing projections. We've done thousands of them over the years. And guess what? We've every single one was wrong. We did our best, but things happened that we didn't expect to happen. We thought the husband was going to die first and the wife died first. We thought they were going to die in Pennsylvania and they ended up dying in California. We thought one thing was going to happen. We thought that the tax rates were going to go back up in 2026, and they didn't go back up in 2026. They're actually at the same level that they were after the Tax Cut and Jobs Act of 2017. So all the projections that we've done have been wrong. Does that mean they're not valuable? No, they're very valuable, but we're never going to nail it. So rather than guessing wrong, making a plan based on something that's going to happen in the future that we can't control, that we don't know what's going to happen, and rather than forcing people to come and redo their wills every 2 years or even more, we have a better solution, the ideal family that it works for. And I'm going to date myself and maybe a little bit you, if you've heard of this, is what we call the Leave It to Beaver family. Original husband, original spouse, same kids, same grandkids. All right. And what are some of the goals of this traditional Leave It to Beaver family? Um, Protect both of us while we're both alive. That's the starting point. Nobody ever came into my office, or for that matter, anybody in the world that I know of, and said, my goal is to make my grandkids so stinking rich they never have to work a day in their life. No, the first goal is make sure that, we are both okay. Then the next goal is, all right, after the first one of us dies, I want to make sure that the surviving spouse is very well taken care of. Then I want to cut taxes, and I want to leave the most possible to our family. And family, let's say for our discussion, is, let's say, children or grandchildren. So what are some of the advantages of leaving it to a spouse? Well, first, spouse gets to roll the money into their IRA. We actually prefer what's called a trustee to trustee transfer, but basically the transfer of your IRA or even Roth IRA directly to your spouse, which is a wonderful thing. Subject to very rare exceptions that have to do with citizenship, there's no state tax, estate tax, or inheritance tax. That's, I believe, every state and certainly the federal government. So that is a great thing, which does not apply to kids or grandkids. Even Pennsylvania has a 4.5% to lineal heirs and 15% to non-lineal heirs. Um, Spouse gets the old favorable treatment for the stretch IRA. All right, so they can stretch that over their life expectancy and the life expectancy of a deemed beneficiary who is 10 years younger than them. For a Roth IRA, there's no required minimum distributions if you leave it to a spouse. And that's what most people want to do. We love our spouses. We want to make sure that they are okay. They are a great choice, the beginning choice of who we leave our money to. All right. But there's some advantages to sometimes leaving some money to kids instead of the spouse. Maybe a child is in a lower income tax bracket. That might be great to leave an IRA to a kid who's in a much lower tax bracket than your spouse. Child might need the money now. So many of my clients, without my encouragement, would just accumulate, 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 die. Huge amounts of money goes to their kids with an enormous tax when the kids are in their 60s and 70s. I've been fighting that for 40 years. I want to see the kids get money earlier so that they can have a more productive and a more meaningful life and a more comfortable life, maybe get into a home earlier, be able to travel more, get their kid into a better school by living in a different neighborhood. And maybe this surviving spouse doesn't need all the money. Then sometimes it might make sense to leave some money to a grandkid. Maybe the kids don't need the money. Maybe the kids have creditors. We even have a name for it. It's the I don't want my no good son-in-law to inherit 1 red cent of my money trust. But we sometimes have, well, it doesn't mean they're no good, but let's just say that you don't want your money going to your future ex spouse, to your future ex kid's spouse. Um, Other good thing, if it's particularly for IRA money, grandchildren might be in a much lower tax bracket. If you do have a grandchild with a disability who can stretch the inherited IRA, literally, our family saved $1 million by skipping my wife and having that money going into a special needs trust for the benefit of our daughter. And that was only based on a $500,000 IRA. So that's an unbelievably beneficial strategy. But even if your grandchild doesn't have a disability, they're very most likely in a lower tax bracket than your kids. So again, if you have that uncertainty, maybe you don't want to name your grandkids, but it sure be nice to have that option because potentially there is a huge savings. And by the way, I will mention that if you do have a grandchild with a disability, you don't want to leave that money to the grandchild outright. You want to have a special needs trust. And depending on the age of your grandchildren, even if they don't have a disability, you most likely want to leave that money to a trust. And that trust should meet 5 conditions, which I won't get into, which most attorneys botch, but that's another topic. But a properly drafted special needs trust does protect eligibility for government benefits while still providing enormous financial security. And if we get this right, the ability to stretch the inherited IRA over the life of the grandchild. So here's the solution. Ready? Don't decide. Isn't that great? You don't have to decide whether it goes to spouse, whether it goes to kids, whether it goes to a trust for grandkids. That is, you don't have to decide now, right? What you can do is have what we call the Lange's Cascading Beneficiary plan. How does the cascade work? The first beneficiary is the surviving spouse. The second beneficiary is typically children equally. The third beneficiary is a trust for grandkids. And typically there is a trust for each set of kids. So let's say you have 2 kids and each of them have 2 kids. If the one child predeceases, or this is coming up with the solution, disclaims, the money doesn't go to his nieces and nephews. The money will typically go to his or her kids, typically in trust, and particularly if that grandchild has a disability. So it's based on the concept called disclaimers, which means nobody can force you to take a bequest. So let's say that you are two grandparents, husband and wife, and let's just pick on the guy because we die first. Typically, we have a shorter life expectancy. Um, and you leave money to your wife, all right? She doesn't have to accept it. Now, she can't say, I don't want it, it goes to Joe the plumber. No, she can say, I want it, or I don't want it, or I want part of it. Well, what happens to the part that she doesn't want? She doesn't get to say that. It goes next in line. And let's just say that you have documents that I like that will have something to the effect like, I leave it to my wife, but if my wife doesn't want it or doesn't want part of it, the part that she doesn't like will go to my kids equally. Okay. And let's say that your wife wants everything but $100,000. And she says, I disclaim $100,000. Then each kid gets $50,000. Or I don't want I want a certain percentage of it. Or I want this asset, not that asset, et cetera, et cetera. We are letting your spouse decide, not now, but within 9 months of your death. And the money goes next in line. And I like to be very clear. If the spouse disclaims, here's where it goes. Let's say it goes to the kids equally. Then you can have something that says each kid gets to disclaim further into a trust for a grandchild. Now, normally a grandchild wouldn't get any money unless both spouses, that is, grandma and grandpa, are gone and their parent is gone. But I'm actually setting up the possibility of kids getting money or even grandkids getting money at the first death, not just the second death and then the death of the children. And adding that flexibility is enormously beneficial that can get money to the right generation, save potentially hundreds of thousands. In some cases, we've saved well over $1 million in taxes. And you make the decision not now, but within 9 months after the date of death, which is really critical that you have 9 months to decide that. So we're starting with grandma, then to kid, then to grandkid. That's a typical cascade. Now we're doing some to great grandkids also. Um, After a death, you have 9 months to make that decision. Use that time wisely. You don't have to do anything quickly. All right. In fact, usually after a death, my advice is don't do anything. There's no huge deadline. Um, Figure out what you're going to do. All right. Get your strategy lined up before you do anything. All right. You don't need to do anything very quickly, except maybe pay some bills. And there's ways to do that and still preserve the use of the disclaimer. All right. I'll also give you a warning. Financial institutions are miserable on disclaimers. They used to be a lot worse than they are now. But if you're disclaiming to a trust, and particularly to a special needs trust, these big organizations, and I don't want to name them because I don't want to get sued, but these big organizations that you would think would know better, they can make terrible mistakes. If we had not been on top of the bank, we would have lost the ability for our daughter to stretch that inherited IRA over her life and should have been out $1 million. And the IRS doesn't care if the bank made a mistake. What are you going to do? Go sue some big bank because, you know, somebody screwed up? I don't know. I don't, I don't know. But I'll just say these institutions have to be watched like hawks after a death. Um, and frankly, if I hadn't known what I was doing, it would have been very easy to botch. And my wife's become very smart about this kind of stuff. We're right on top of these people, but they were still making mistakes. And even after we explained it to multiple people, then a new person came in and was about to make a big mistake that would have just wrecked the whole thing. And many disclaimer opportunities have been ruined by premature action, often the client, by the way. Husband dies, wife says, "Oh, I'm going to save some money on attorney's fees. I'm going to do this work myself. I'm going to transfer that IRA to my name because I'm the primary beneficiary." Oops, you missed your chance to disclaim. I'm telling you, this happens. It happens plenty, even for people who have disclaimers in their documents, even for people who went through a process with our firm and who we said don't do anything until you figure out a strategy. Um, all right, so here's and this is a facts change to protect confidentiality, but it's basically true and it's oversimplified. So mom and dad have 6 million bucks. All right, I should say grandma and grandpa, but it could be mom and dad. They have 6 million bucks, all right, and three kids. They're not big spenders. All right. 3 million was more than enough for grandma to live. She had a paid up house, she had certain habits. Probably she could have lived on 1 million, but we were being conservative and said, okay, $3 million, safe withdrawal rate for 20 years. Let's say it's 5%. That's 150 plus Social Security. You're at 200,000. Right now you're spending 100,000, more than enough money. All right. So what do you do with the other 3 million? All right, so dad dies, 3 million's more than enough for mom. She disclaims, which was anticipated when the documents were done, and she disclaims, she just said, I disclaimed 3 million bucks. All right. So what happens is there's a provision in there. If mom disclaims, the 3 million, whatever she disclaims goes to her kids equally. All right. And what happened was each kid used their $1 million differently. One beefed up their own retirement plan. They made Roth conversions. They funded college. They spent some, and they saved the rest. Another one disclaimed to his kids for massive long-term savings. Another one bought a beach house. So, and by the way, then mom dies 10 years later, but the benefits of having the money distributed to the family was huge, not only in terms of taxes, which did happen, but the people that had the beach house, they were in the beach house 10 years earlier. So they got 10 years of use of a beach house that they wouldn't have had if they didn't utilize and actually do this disclaimer. So this was just a wonderful benefit, and all these benefits would have been wasted, and typically they are. And this is, we call it Lange's Cascading Beneficiary Plan. And by the way, if you go to Google and you just type in Cascading Beneficiary Plan, there'll be hundreds of thousands of entries because I've been talking about this for many years. Most of them are going to point back to me in one form or another. And if you like the idea of it, I like building in lots of flexibility. It works for wills, after tax dollars, revocable trusts. It works for IRAs, retirement plans, and Roth IRAs, and Roth conversions, and annuities, and properties, et cetera, et cetera. So this to me is a wonderful starting point. Now you do have to trust your spouse, and it's not going to be appropriate, say, if your spouse is your second spouse and she has her kids and you have your kids, because if you leave everything to her, she might not disclaim anything and she keeps it, and then all the money goes to her kids down the road and your kids don't. So although I don't know, maybe you do trust her, but I'll just say it's not for everybody, but it works very, very well for these traditional families. And with that, why don't I take a few questions about it before we move on? Erica, do we have any questions on the Cascading Beneficiary Plan?
We do have some questions. Sorry, I was a little bit caught up because I actually Googled Cascading Beneficiary Plan just now, and I think it might be because I'm doing it from a work computer, and I do work here. But the AI overview actually says a cascading beneficiary plan, specifically Lang's cascading beneficiary plan. So, anyway,
I actually
um,
didn't know that.
I didn't either. I'm surprised. That's why I had to share it here. Um, so we do have some attendee questions so far. None are particularly specific to the Cascading Beneficiary Plan. Uh, well, no, that's eligible designated.
Go ahead, whatever it is.
Okay, so Gregory asked, does the kiddie tax apply to a grandchild without a disability? Or with a disability, I think would also be a question that I saw somewhere in the chat.
Okay, well, with the kiddie tax refers to when you have a young child, and I think it's up to age 12. What they're going to say is what we used to do is we used to have money going to young kids and they were in a lower tax bracket. We saved a lot of money. Then somebody came along and said, hey, that's not really cool. We're going to tax these kids at their parents' rates. So um, that so some of those strategies weren't as effective. On the other hand, at a certain point, I should remember some of these details, but I think after age 12, it doesn't apply. Um, and it does not apply to a special needs trust. I'm not 100% sure of that. Let's say 95% sure of that a special needs trust would not be subject to the kiddie tax rules. Ready for another one?
Yes. Uh, the next question is, and this one you might actually want to save because it's kind of a complicated answer, but Marianne asked, can you define eligible designated beneficiary? She said, so your grandchild can be disabled to get the stretch. So basically, what an EDB is for the purposes of qualifying to stretch a IRA or inherited retirement plan.
All right, first, I'm going to give you the definition that most people think is the right definition. Then I'll tell you a definition that's a little bit more nuanced, and then I'll tell you an even more nuanced uh, definition. So, usually, when you think of eligible designated beneficiaries, you think of kids with a disability who typically have qualified for SSI or SSDI, both of which are government benefits. And very frankly, the disability has to be relatively profound to qualify for either of those. Our daughter, by the way, even though if you spoke with her, you would think she's a very articulate young woman. She could do a physics problem very well. She can beat the pants off of me and my wife in Boggle combined. That is when we're playing as a team and she's playing. So many things that she can do, but she has some profound problems that will not allow her to work. And she did qualify for SSDI. She is an eligible designated beneficiary, which means when we die, she can stretch the inherited IRA or Roth IRA over her lifetime, or the strategy that we used, which is coming up, is when her grandfather died, we disclaimed it into her trust, and her trust is going to be able to stretch that inherited $500,000 IRA over her lifetime. That's the easy one. Then there's another path that you can go to the IRS, and the IRS is always going to start by taking what the Social Security Administration has deemed. So if the Social Security Administration has qualified the child for SSI or SSDI, end of story, the child qualifies. By the way, that was not always the case. Before, you could qualify for SSI or SSDI, and then the IRS could say no. Then they changed that and they said, no, no, if SSI or SSDI applies, it applies to you. Now there is a new area that I'm fantastically excited about, um, which is qualifying as an eligible designated beneficiary when the child or grandchild doesn't receive SSI or SSDI, but does have other attributes that will allow them to qualify. So, for example, right now, and it just irritates me to no end, we have clients who have been denied SSI or SSDI because they have the capability of working. So I'm thinking of one girl who is on the autism spectrum. She is able to work at a grocery store, bagging groceries, and she does earn money, which disqualifies her for SSI. On the other hand, she will qualify when her parents die to stretch the inherited IRA. That is the area that is new that hardly anybody knows about. The other cool thing about that is you can get, in effect, letters not necessarily from an MD, but somebody else who is treating the child, like a nurse or a psychologist, et cetera, et cetera. So hope that is helpful. But the easy one is the kid is already receiving SSI or SSDI, which, by the way, Debbie McFadden calls that the golden ticket. And Debbie is one of the co-authors of Retire Secure for Parents of a Child with a Disability. All right, but why don't we take one or two more and then we'll move on?
Yes, great. Um, so this question comes from Joel, and he says, if all of your IRAs have been converted to Roths, does the cascading beneficiary plan have any tax advantages for your heirs?
Well, sure it does, because even if all the money's converted to a Roth, the question is, do you want that to go to your kids or to your grandkids? I'm assuming that the spouse is, oh, but I shouldn't assume that. Maybe we want the spouse to have it for a while and have more money coming out with no minimum required distribution. Remember, you still have a required minimum distribution of an inherited Roth IRA, which is typically 10 years, again, over the lifetime for a eligible designated beneficiary. But yeah, there's great advantages depending on where you want that money to go. Uh, and you might not know until well after the first death. So, well after the first death, you find that the kids are in a very low tax bracket, and it makes sense for, and it doesn't make all that much sense for a Roth IRA to go to them, but maybe the grandkids are in a very high tax bracket, and the Roth would really help them. So you don't know what's going to happen. I'll also tell you this. I actually got an interesting question, and it was from the son of a friend who I just wanted to help out. And he said, "What is the best way for me to convert all my IRA to a Roth IRA?" And I said, "That's the wrong question. We very rarely recommend converting all your money from an IRA to a Roth IRA. It's usually a portion of the IRA, not all of it." All right. And why don't we take one more and then we will move on?
Um, okay, this one comes from Craig, and he asks, where is the option to disclaim made real? The heir can disclaim, but does the will or the trust document need to articulate something?
That's a really good question. So the law is you don't need to say it, if grandma doesn't want it and she disclaims, it goes to the kids equally. You could have disclaimers without having that language. I'll tell you what the real problem is and why it's so important to have that language. Because without that language, hardly anybody disclaims. Very, very few firms talk about disclaimers. A lot of times I have clients who have parents who died, and then I come in knowing that, let's say, my client's parents or one of them died, and I say, hey, wait, you have plenty of money. How about if you disclaim to your kids? And again, they can't say I disclaim to my kids, but they can say I disclaim. Then we go back to grandma and grandpa's documents, and it says, and it doesn't say my beneficiary has the right to disclaim. It says if my beneficiary is dead, then next in line, that's so if my kid is dead, next in line is their kids equally. So you don't need to have that language. I will just tell you, if you don't have that language, it rarely happens. And we're doing a lot of documents that, frankly, because people are moving and there's a lot of change. I could do a document in Pennsylvania, somebody ends up dying, and by this point they've moved to Kalamazoo, and uh, so now I'm the Kalamazoo attorney, and I'm looking at the will or in the trust and the beneficiary designation. It says, what's this disclaimer language? And it puts the future attorney or the future beneficiary on alert. Hey, mom and dad were thinking about this when they set this thing up. Maybe we should try to figure out what was going on. Now, if you're a lifelong client, by the way, we're going to keep reminding you. And even after I sold my law firm, I still send newsletters to all my old legal clients, just because that's what I want to do. And we're talking about a hard copy newsletter, and I keep sending them every book that I publish because I just feel like I have an obligation to do that, and I want to do that, and I don't want to see people screw it up because I don't want to. I don't want to create these beautiful, wonderful estate plans, even if I'm not practicing law officially anymore, and have somebody screw it up because they make a mistake. So I write about disclaimers very frequently, even though I will not be the attorney of record when these folks die, and not just because I might not be around, but because I sold the law firm. So to me, can you do it? Yes. Um, is it smart not to have the language in the documents? I would say no. I would say no. I want to see that language. I also want to be very explicit. If you disclaim, here is where it goes. I just too many bad things have happened when you don't get the language right. All right. And by the way, before I go on to the next topic, I will mention that we will be providing an opportunity to not to draft wills and trusts and beneficiary designations, but to be your advisor, most typically under an assets under management model. And the way you get started, and this is in effect a chance to step in front of the line. And interestingly, this is the best attended of the three webinars. We've what 300 people who signed up for this, and most of the people are actually still on. But anyway, if you do qualify, and by the way, you have to get through me because I look at every single one of the people who are interested in a consultation, and I get to decide who gets them and who doesn't get them. And you have to get through me. My biggest criteria is, can we help you quite a bit? If you're in a situation where I'm looking at your wills and they look pretty good to me, which doesn't happen often, your Roth conversion strategy looks pretty good to me, and that doesn't happen very often, and we don't think that we could add a lot of value, that's not exciting for us to to work with that kind of client. We prefer, and a lot of times the client doesn't see the opportunity, but we see it. We want to really make a big difference. And in fact, if you do qualify, and at this point, the consultation is with me and one of the number crunching CPAs. Um, but if you do qualify, then we set that up. Again, it's not for drafting wills or trusts. Okay. Um, why don't we? Oh, this is a case study coming up. All right, why don't we take one more set of questions, and then I'm going to actually reveal what I did for my own family that is going to save my own family $1 million plus in today's dollars. Why don't we take one or two questions before we go on to that?
Sure. The next question comes from Bill, and he says, with the Secure Act limiting the stretch for most beneficiaries to 10 years, isn't it usually foolish to skip the surviving spouse who can stretch the inheritance longer?
Good question. And Bill has what I call larceny of the heart, which he's looking out to squeeze the last drop. It very well might make sense if the only goal is to stretch it longer. On the other hand, a lot of times the IRA is the biggest asset, at least for our clients. We tend to be our clients tend to be IRA heavy. And if we want to get some money to the next generation, sometimes the IRA is the only way to do it. And sometimes the kids need the money now, whether it be for housing or for um, paying for a wedding or a down payment for a home or for piano lessons or for getting into a better neighborhood or for whatever the expenses that they have, might even be life insurance for them. Um, and the parent wants to help them out, sometimes that's the only way we can do that. We disclaim it to them, and if they're in a lower tax bracket than the surviving spouse, then they can withdraw the money, and we end up in a better tax situation than if we didn't disclaim and then had the spouse take money out of their IRA at the higher rate, particularly a single higher rate, when we would have been much better off disclaiming. So if the only goal is to defer the IRA distributions, yes, we could probably get a better stretch with the spouse, but that might not be the only goal. All right, and why don't we take one more and then we'll move on.
So this next question comes from Richard. I think it's pretty good. It's a bit general, but I think you're going to have a good answer. Do trusts have high costs or hassles for beneficiaries?
Well, there's always a hassle factor for trust. Who's kidding whom? You know, I'm a cheapskate. I tend to be a little bit more trusting, certainly, than my wife. And I kind of like family members. Uh, Other people like banks. Other people like, let's say, there's smaller trust companies that might be, that might be preferred. So, is there always some kind of layer to and disadvantage of a trust in terms of administration? The answer is yes. If I have, a grandchild who's perfectly mature and we're leaving them $100,000, am I going to put that in a trust? Most likely not, because of the aggravation and lack of benefits. In fact, even sometimes a trust that, well, we used to draft said, hey, the trustee, in using their judgment, if they want to terminate the trust, they can terminate the trust. We usually do that to keep things simple. But let's say it's not so simple, and let's say the trust is appropriate. Then let me get back to the question. So the question basically says, gee, Jim, I heard trusts have really high rates. In fact, trust rates are the same as married filing separately, which are the highest rates. So even if the kid doesn't have a lot of money or doesn't have a big income, the trust might be taxed at a very high rate. And that's true, except there is something called an income distribution deduction. So let's just say, for discussion's sake, that the trust earns $50,000, all right, and they have $50,000 worth of income before a distribution deduction, and that $50,000 would be taxed at the highest rate. But let's say that the expenses of that child is $50,000, and the trust writes a check to the child or pays expenses for the child totaling $50,000. All right, now let's do the trust tax return. $50,000 worth of income, less distribution deduction 50,000, taxable income to trust 0. Then the trust has to file a 1041, which is like a 1040, but it applies to trusts and estates. And then the 1041 has a K1, and the K1 goes to the kids. So you see why the complications are not nothing, but then the kid gets a K1 and says, kid, you have to pay income tax at your rate, which is going to be much lower because they're taxed as an individual instead of the same very high trust rate. So we can get around that high trust rate if we're having some distributions. Long-winded answer to a short question, but it is a little bit of a nuanced answer. Okay, so now I'm going to switch. People like stories and case studies, so I'm going to do one, and it's the one that's really exciting to me, and it was shared and it was actually in the Wall Street Journal and it was in Forbes.com. The clicker isn't moving forward, but I know this one pretty well. So I will just go ahead. Oh, there we go. We got the clicker. All right. So my father-in-law had roughly $1 million in his IRA, and he was planning to leave it 50-50 to his kids, which makes sense. Um, and then I said, his name was Walter Weinstein. I said, Walter, right now you have the beneficiary of your IRA, by the way, not a Roth, just plain old IRA, $1 million, half goes to my wife, Cindy, and half goes to her brother. Could you add, and I gave him the exact language, the ability for Cindy to disclaim her share of the inherited IRA and have that money go into a special needs trust for the benefit of our daughter, Erica? Erica has there's two tax saving features to this. Number one, Erica is in a lower tax bracket, notwithstanding the fact that it would go into a trust, but the trust is paying for her expenses. So it is going to have a distribution deduction. So it will be at her low bracket instead of my wife's, who is in a much higher bracket than her. And my wife would have to take all that money out within 10 years of Walter's death instead of being able to stretch it out over the life of my daughter, who's 30 years old. So let's just oversimplify. It's actually more than 50 years. So she'll be able to stretch that for 50 years instead of 10 years. And when you combine that with the lower tax bracket, the savings on that is going to be over $1 million using some not out of line assumptions because our daughter does qualify as an eligible designated beneficiary. And the way we are doing that is, and by the way, the history of that is Walter did pass. He passed at 101. Many of you are familiar with Walter because he kind of was the inspiration for the best way to spend your money, which is to take your family on vacations and to spend it on experiences. For the last 30 years, my daughter has been visiting her cousins and her aunts and her uncles, but mainly she likes the cousins. And very frankly, when she developed her disability, a lot of her friends deserted her. Her family did not. And she feels like she is part of a clan. That is her favorite time of year. And interestingly, even though he sponsored this for the last 30 years, the family has found so much benefit to it that we are maybe not to the extent that Walter did, because none of us are going to have the kind of money or want to spend as much, or not everyone wants to spend that kind of money, but we want to keep this family tradition going. But anyway, he passed just last year, this past December, at age 101. Um, Half of, and to oversimplify, the actual number wasn't, but I wanted to make it simple. $500,000 went to Cindy. Well, it would have gone to Cindy. She disclaimed. The banks tried to, well, they didn't try to screw it up. They almost screwed it up multiple times. We ultimately got that money into Erica's trust. She'll be able to stretch that out. So right now she's 30 years old. Let's say, for discussion's sake, that the table for a 30-year-old is 50 years. So she only has to take out 2% and pay tax on 2%. And then next year it'll be instead of 1 over 50, it'd be 1 over 49 times the balance, 1 over 48 times the balance. And the combination of her being able to stretch that inherited IRA over her lifetime and the fact that she's in a lower income tax bracket than my wife and me will end up being over $1 million in savings measured in today's dollars for our family. To be more precise, $1,178,397 over our daughter's life. And if you look at this chart right now, and by the way, this chart was published by Forbes.com, age at year zero, that's the year of death. All right, so it's a tie, whether it goes to my wife or whether it goes to my daughter or the special needs trust. But after 10 years, because we have that lower distribution and that lower tax rate, my our family's already $200,000 better off in 10 years. In 20 years, the family is almost $500,000 better off, et cetera, et cetera, et cetera. So at the end, and again, we're apples to apples, same spending. The things that are different is the trust gets to take it out slower, which means less taxes because it's a longer stretch and a lower tax rate. The difference is between 2,860,000, which ends up being 1.17 million, but that's in today's dollars. This is so cool. This, by the way, I really want, I think right now, according to the real quick unscientific poll that we took, roughly 15% of you have a grandchild or a child with a disability. I would like this information going out to every grandparent with a grandchild or a child with a disability. Is this going to make sense for somebody who has 50 or $100,000 in an IRA? No, because again, I don't take this trust and the fees and the CPA to do the 1041 and all the. I don't take that stuff lightly. So if I can only save 10,000, 20,000, I'm not all that excited. If I can save $1 million in today's dollars, I'm very excited. I would love to see a lot of grandparents do this. And like I said before, the definition of eligible designated beneficiary goes well beyond just qualifying for SSI or SSDI. We have this whole new area that I think is just going to make an enormous difference. As far as I could tell, there's probably at least 500,000 grandparents who have $1 million or more in an IRA that even if they have two kids and they still split it equally, 500,000 a kid, this can be an enormous, enormous benefit. And I will tell you, you're not just benefiting your grandchild, right? So Walter, his big thing, not that he didn't love his grandkids, but his big thing is he wanted to take care of his kids first. Well, my wife, her big thing is she wants to take care of Erica first. All right. So by setting this up, he's not just helping Erica, he's making his daughter much happier. And I will tell you, if you have a child with a disability, that has been my wife's biggest concern for many years, which is what's going to happen after we're both gone. And you can only save so much, you can only work so long, although I keep working and working. Um, and you can only cut your expenses so much. It's the strategy of doing this. And here we're picking up an extra $1 million. And very frankly, my wife is not going to miss the $500,000. We're in a fortunate enough position that that's not going to have a huge impact on our life. Um, and it will have a huge impact on our daughter's life, and that makes my wife happy. So this is a win-win situation. I realize this is a specialty situation, but let's even just if I said, okay, what if the kid didn't have, what if the grandchild didn't have a disability? What if they were just in a lower tax bracket? Well, you wouldn't see $1 million savings. You might see a 500,000, might or 300,000, or something that was significant enough that it was worth doing this. And if you do it on a disclaimer basis, then you don't have to worry about it now. You can let the survivor worry about it at within 9 months of the first death. So I think that this is very, very cool. Again, it was in the Wall Street Journal in December. I think it was December 22nd. It was by Ashley Ebling, who she did the original Forbes article. Then we had that Forbes.com article that basically was this story. It was basically my family story in Forbes.com, and which is wonderful because Forbes.com is very well respected and highly read. Um, and it was called How Grandparents Can Best Provide for a Grandchild with a Disability. Okay. And by the way, the assumptions are we assume the $500,000 inherited IRA. By the way, we didn't use outrageous rates at all. We did a 6% rate of return, 3% inflation. I could have used, if I had used 8%, which is more indicative of what historically the rates have been, the benefit would have been way more than $1 million. And I think that that's what will happen. And we assume that the parents were at a much higher income tax bracket than the child or the grandchild. We assume that all the money was spent. We assumed current income tax rates. Uh, we said tax on portfolio was 15%. We didn't take inheritance or state income tax into um, into account. And maybe this opportunity, especially if you have a grandchild with a disability, but even if you don't, you have a retirement plan with children and grandchildren, it might work out very well um, for you and your family, particularly if your child is willing to consider disclaiming in favor of that child, or better yet, a special needs trust for that grandparent for that child. I'm sorry. Of course, your grandparent does have to be alive, or in your case, you have to be alive. Still have to have capacity to update this, uh, let's say, strategy. And if so, don't wait. Do it now. And then the cherry on top, Roth conversions. Walter never made Roth conversions, but Cindy and I did. And our daughter will be significantly better off because when we made a $240,000 Roth conversion in 1998, which is now 2.2 million, I know already that my wife and I will never spend any of that money. And when you have a child with a disability, you're particularly with the way healthcare is going right now, where I believe we're going to have two tiers. One is private, one is public, and the private one is going to be very expensive. And if you have a disability, this stuff can be a lot of money. But I feel like I am providing for my daughter in the best possible way, in a way that she could not provide for herself. Um, so with a Roth, it's long term, it's tax free. Converting a portion of it to a Roth, directing that Roth to a special needs trust is even bigger than any of the numbers that we did to enjoy 80 years of tax free growth on a Roth conversion made in 98. Very, very cool. And like I said, the stretch isn't limited. The lifetime stretch is not limited to beneficiaries who receive SSI or SSDI. It also applies to, let's call it this in between, people with certain limitations that don't qualify for SSI or SSDI, but do qualify for the trust, for the stretch. Stay tuned, that article is coming up. Okay, and by the way, well, I don't even want to get into it, but I also say that you don't need a doctor to sign off on this. This can be done by a licensed healthcare practitioner. Um, and this can be enormous for the family. And you could have the same cascading beneficiary plan qualify for this. And it can be, the benefits are just enormous. And to get this right is just makes such a difference for your family. Okay. And again, a lot of people have certain conditions that don't qualify for SSI or SSDI, but maybe Downs, maybe they're on the spectrum, maybe early onset Alzheimer's. Um, it, it, I think that this is going to be big. Okay. Why don't we take, let's see, do we have more time for questions? I guess we don't have a lot of time. Why don't we take a few minutes and take some questions. How's that? We'll do a compromise.
That sounds great. And I think that we definitely have a lot of really good questions from this session and even some leftovers, carryovers from the first and second sessions. So I think that this is definitely one that we're going to be answering some of these on our YouTube channel, the ones that we don't get to today. So one question that I think you might be able to address pretty quickly, Jim, is from Marianne. How old does a child have to be to inherit money? Just at all.
Well, they can be one, but it's not smart to leave it to a 1-year-old outright. You want to have typically you have a minor's trust. Um, I've been talking about a special needs trust, but I won't say it's just age because we've done trusts for 40-year-olds because they're spendthrifts, they have a drug or alcohol problem, we have the no good spouse. No, you could have 1-year-old inherit money in a trust, and that works well. The only area that is hard is money going to an unborn child. The planning on that gets tricky. I like to have the kid at least born before they get the money. But I won't get into that because that's a detailed issue. And frankly, we don't do trust for unborn kids because of a lot of technical problems. By the
Here's
way,
another.
they can be unborn at the time you're drafting. They just have to be born before you die.
That makes sense. Here's another one that may have a shorter answer. Sharon asks, does disclaiming work with a Roth IRA or only with a traditional IRA?
Oh no, it certainly works with the Roth IRA. In fact, it works with any asset. IRA, Roth IRA, after tax, high basis, low basis, annuities, real property. You can disclaim most anything.
And actually, that gets into a question we had in the Q&A from an attendee who said the IRA passes outside of a will, so how do you disclaim?
You disclaim by through beneficiary designation.
And that's a form, right, Jim?
Yeah, it's a form. Interestingly, there is no federal form on how to disclaim. Sometimes the institutions have their own form. Sometimes we've made up the form ourselves. Um, but there is no, it's not like a Form 1040 or a 1060 or anything like that. And it's also state specific because even though you can disclaim in 50 states, you still have to meet the laws of each individual state, which is basically identical. I think they're all 9 months. Although I never comment on Louisiana because that's with the Napoleonic Code, and that's a whole different beast. But it's state law that controls disclaimers.
And then Bill asks, with the who gets what strategy, can you use one single trust to differentiate beneficiaries of traditional IRA, 401k from Roth IRA?
Well, all right. So the who gets what, which is, by the way, it's a 20-minute discussion. This is the first time I haven't covered that in a couple years because I knew I was going to run out of time. But basically, it's directing different assets to different beneficiaries based on what's going on in their lives. So I talk about disclaiming IRAs to charity, for example, or even not disclaiming, just leaving IRA money to charity because charity doesn't have to pay the income tax. I like to have Roth IRAs go to high income kids. I like traditional IRAs to go to low income kids. A whole strategy that I usually cover takes 20 minutes. I, I just didn't have the time to do that. You can use it with disclaiming. It's a little bit trickier then, and I don't want to take any more time on that. I'll just say it's a very cool strategy that I do cover at length in the books that are going to be your bonuses that Erica's going to talk about after we are done, but we're not there yet.
Yes, and then I'm just going to give you one more. That's a very quick answer, and then we need to get back into the presentation because we're almost out of time. But James asks, I'm a widower with no children. Can this situation, I believe he's describing a cascading beneficiary with disclaimers plan, can this situation work with my brother and sister, my nieces, nephews, and my great nieces and nephews?
And the answer is very good, because what you did, which, James, this is gold star on this. I probably could have said it, but what you're doing is in effect the same thing where so this is the way it would work mechanically. Let's keep it simple. You have two siblings. I leave all my assets and my IRA, my retirement plan, my Roth IRA. It might be in different documents, but I leave them all to my siblings equally. If one of my siblings disclaims, then their share goes to their kids equally, which is your nieces and nephews. If one of my niece or nephews disclaim, it doesn't go to his or her brother, it goes to their kids. So what you've done is you have, and it kind of used the concept of the disclaimers and the cascading beneficiary plan. I would even say that that plan is the cascading beneficiary plan, even though the classic cascading beneficiary plan, which by the way has been trademarked, is spouse, kids, grandkids, maybe great grandkids. For you, it's siblings, nieces, nephews, grandnieces, and nephews. Very good. Okay, I think I am going to move on. Um, Eric, if you can give me my clicker back, I would appreciate it. Um, I am not getting my clicker, so I will just do this from memory. Oh, there it is. Um, I will just tell you, you could do some of this stuff on your own, maybe a lot of it. I will just tell you, it's so easy to screw this up. All right. You really want to get the right attorney. You want to get the right team. You want to get the right advisors. Because given a chance, the bankers are going to screw some of this up. I'm telling you, they are. They almost did it with us. Um, and you lose that opportunity. Um, so I don't want you to use let's call it the trial and error method. And again, if you're a do-it-yourselfer, you're a do-it-yourselfer. But if you are if you see some of the benefits of some of the things that we've talked about today, like getting the safe withdrawal rate right, getting the Roth IRA conversion right, getting the estate planning right, getting the cascading plan right, getting the who gets what, which we didn't talk about today, right, and you see some of the benefits, and you see the benefits of having low cost index investing by really smart people doing really good work, you might consider putting our team to work for you. And the way you do that is ask for a retire secure consultation. At this point, I'm the one who decides whether you get the consultation or not. One of my main criteria is, can we help you a lot? And right now, that consultation will likely be either with Jen or Dom. They are both our veteran number crunching CPAs. The apprentice, who has only been in the field 20 years, but he hasn't, you have to work probably 3 years before you have to start with a seasoned CPA. Then you probably need about 3 years individual training in our office. We have you go out and get some formal training. And believe it or not, we actually do every Friday afternoon, the CPAs go through, let's call it, we don't get credit for it, but it's informal learning. Often the main presenter is Steve Coleman, who is no longer available for work. He's been with me over 30 years now. He's booked. He doesn't have any more room, um, which is why the consultation will be with Dom or Jen, who have joined me more recently. But they're still learning. But you'll have me, you'll have either Dom or Jen, and then you'll have the 20-year veteran, but not a veteran of our firm, who will one day be a Jen or a Dom. Um, but the first step is putting us to work for your family. We ask you to fill out a lot of stuff, list of assets. I actually look at your wills and your trust and your beneficiary designation and your tax return and your list of assets. So I actually put a fair amount of time into this, which is why I'm not going to just give anybody a consultation, because I want to be effective with my time also. And then here's what we do at the end. We do this really good memo, right? It's a roadmap. It can be for you, for your estate attorney, your CPA financial advisor, um, whether it's one of us or somebody that you work with. It's really valuable. It really is. And sometimes people have got hundreds of thousands of dollars just from that. Many clients have said how wonderful and how helpful it is. And we actually prepare for this. Dawn and Jem, um, they actually do some preparation. They do some spreadsheet work even before you are on the phone. They're looking at and by the way, Roth conversions, mission critical. Estate planning, mission critical. But these are only two of the areas. We're also looking at safe withdrawal rate. We're looking at the big picture. We're looking at gifting. We're looking about, the no good son-in-law. We get into all those areas that we think provide enormous value. Um, and we think, I genuinely believe we have the best assets under management arrangement in the industry because you get a great money manager who, by the way, they would charge it's 1% on the first million and then it goes down after a million. But you get a great money manager. I'll talk about that person. But you also get us for the same cost, right? And the money managers are data driven, best academic research. They really are good for service. Everybody says it, but they really are. They have the best asset allocation and asset location, meaning they're going to invest your Roth differently than your IRA, than your after tax dollars. And if you do decide to move forward, you get the full team. You get me, you get our CPAs, you get our money managers. If you have an estate attorney that you like, great. Or we can potentially refer you to one. Um, it's a lot of value, and you're going to get a lot of advice, a lot of analysis up front, and we do have, let's call it a fee for service financial master plan. Right now, there's a long wait list for that. I don't know if we're going to get to any more people, but we have not cut that off yet. Um, but realistically, the best way, if you're really interested in working with us, is under this asset under management arrangement. And again, if I don't think that we can provide a lot more value than the fee, we're not going to take you as clients. There's a $1.5 million minimum that will probably be going up. Um, we do a lot of work during that first year. Um, Reviews by the money manager on the investments. And even after that first year where we do a lot of work, we're still spending about 6 hours of a highly trained CPA per year per review. A couple hours to prepare, a couple hours to meet, and a couple hours for a conclusion and a report. I will tell you, I invest the same way that we're proposing that you invest, which are basically low cost equivalent of an index. Technically, they're not an index, but it's really the closest thing is Vanguard, frankly. We're all fiduciaries. We always act in the best interest of our clients. And if you think that you are a good candidate to work with us, click uh, in the box. Justin will actually, Justin, I'm going to ask you to put down the where they could click for a consultation. And Justin will give you, assuming you pass muster with me, Justin will give you a call to schedule. It can be in person if it's in Pittsburgh after May 15. I'm right now in Tucson. I'm a working snowbird. Um, but I like in person, but I won't be in Pittsburgh until May 15. I don't have really a formal office in Tucson, so I'm not going to meet people in Tucson. Or most likely, I used to have most of my clients were originally from Western Pennsylvania. Now, particularly after COVID, I have a national practice because I had written a whole bunch of books, at a radio show. I was known nationally. And then after COVID, it didn't matter if your advisor was next door or 3,000 miles away. You couldn't see him in person anyway. So we became national. Most of our work, frankly, consultations these days is over Zoom. And our office will, Justin is really good about finding a convenient time, getting it set up, making sure that we get all your information. I've done thousands of these consultations over, it says 30 years, it's 40 years. And not once has anyone said or even implied it wasn't worth their time. People came in the old days, people flew in, they drove in hundreds of miles. I still get some of that. Most of it, again, is Zoom if it's remote. And you're going to get a lot of value even before any money is managed. Um, and if I don't think that you're the right fit, I'm not going to tell you to go with us. Uh, we've never recommended a strategy. Oh, promises. I can't promise you what the investment rate is going to be or the rate of return. I'll tell you, I think that these people are really good. They're really smart. Their service is really excellent. Um, I will tell you that not the majority of our family's wealth is managed exactly as what we're going to recommend to you. I'm not going to recommend, something that is much different. Um, CPAs do spend a lot of time on each review. We are true fiduciary, which is legal and ethically required to always put your interests ahead of ours. And the way you do that is you click on the chat box and Justin will give you a call.